Where the rule of law works well, it is not indifferent to the lives of people, to use the words of Amartya Sen. And through rules and institutions, the rule of law seeks to correct the imbalance of power. And in that sense, the rule of law actually provides an ethical framework for the SDGs. The balancing of interests, intergenerational interests as well as intragenerational interests, requires transparent rule-based processes and mechanisms that can ensure appropriate, inclusive, and equitable arrangements acceptable to all. And broadly speaking, that is the real value that the rule of law offers to sustainable development. So, as I said, the rule of law is a legal concept, but it's also a political construct. It's about how societies are organized and how power is exercised. And understanding the political economy of the rule of law is very important. The nature of reforms, their impact on diverse interests, the power dynamics that drive or hinder the reforms, all that is extremely essential to understand if we are to advance sustainable development. Now, the rule of law takes decades, if not centuries, to take hold in a society. And too often, international actors, and I say that as head of one of those international actors, too often we seek to hurry things up because we have no time. We have to report on results. Our donors are putting pressure on us. And so what we tend to do very often is take legal implants from one country to another. Too often, I would say, governments treat these kinds of reforms as technical exercises. Neither is right. And I think the 2030 Agenda for Sustainable Development gives us an opportunity to share experiences and to invest in institutions as well as in the empowerment of citizens, to take a new approach to development. And I believe India's experience will be invaluable, not only for people in India, but also in other countries. Now, IDLO, my organization, has worked for 30 years in some 85 countries, including post-conflict states, transition economies, and middle-income countries. And let me draw 3 points from that experience very briefly. First, if development policies and legal reforms are to be sustainable, they cannot be dictated by outsiders. They have to be locally owned and locally driven. The justice-making, particularly the justice-making effort, the legal systems of each country, is unique. It's deeply rooted in their specific history, politics, jurisprudence, values, customs, traditions. Understanding that local context is critical to the success of any reform. And in building local ownership, it's important to ensure inclusive participation. This can be very politically sensitive. My organization works in a lot of post-conflict countries where, of course, the conflict itself was a result of a power struggle among different groups. So including them all in the legal process can be difficult because the winners may not want the losers in that process. But it's extremely important that happens. And sometimes external facilitation can help that process. Working with people to make things change. Now, in Uganda, we have devised co-creation workshops. We're looking at community justice at the grassroots level, looking at local authorities, looking at informal justice. Co-creation, we sit down with them, and it is these various partners that actually design the work that has to be done. Our presence simply ensures that everyone is included. Mali is another country recovering from years of armed conflict, very poor. And there we have worked with an innovative methodology called program-driven iterative adaptation. Sounds very complicated, but effectively what it means, listening to people, getting them to analyze the problems, getting them to then draw up the solutions, getting them to work on it, and then getting them to revise it as they work and as problems emerge. My second point would be that successful reforms for sustainable development need both a top-down and a bottom-up approach. And that means legal empowerment strategies alongside institutional and legal reforms. Yesterday, I was at a meeting with civil society groups, and a lady there described to me the legal awareness program that her organization runs for women's groups. And she talked about these women who had never read the Constitution and how their faces lit up when they read the preamble of the Indian Constitution, which, by the way, is a very uplifting document, as we all know. And these women, with not very high levels of education, how empowered they felt that the Constitution itself gave them these rights. In the same room was a very seasoned, elderly constitutional lawyer who felt bitter about the Constitution, who felt that perhaps the Constitution was not being applied and used in a proper way. And this lady from the NGO showed us the difference between people on the ground who see the Constitution as an enabling and empowering instrument, and whereas, of course, seasoned lawyers may feel otherwise. I won't have time to tell you about the work that we're doing in places like Afghanistan with women's groups, helping them to address the issues of gender-based violence, working with women's shelter networks, with legal aid networks, but also with the government, building prosecution units that can prosecute for gender-based crimes. Now, my third point is that most people actually don't access justice through courts or formal means. Most people actually, for them, courts are too expensive, too remote, too time-consuming, too far away. And people turn to informal or customary ways of resolving conflicts. Now, these customary systems are very good and effective, but they do have their defects as well, especially when it comes to discrimination against women or against minorities. The power play works out at the community level in exactly the same way as it does in the broader society, and sometimes even worse. And yet there's very little interest actually shown by most governments or by international actors in what actually is happening on the ground. And this is an area that more attention needs to be given. And my final point I want to make is to come back to what Professor Chaturvedi was talking about, the relationship between international rule of law and the national rule of law. The Novartis case that I mentioned is a positive example of that relationship, because the Supreme Court used the flexibility in the World Trade Organization's TRIPS agreement to rule against Novartis. Now, the international legal and institutional frameworks for trade, investment, intellectual property, technology transfer are very important for sustainable development, but power, or rather the lack of it, can tilt interests just as they do in national situations also at the international level. And developing countries like India have been a leading voice, have long called for fairer international rules to create a more equitable, inclusive, and sustainable model of development. And because of this uneven balance of arms, have taken steps, as you mentioned, to terminate bilateral investment treaties, because they feel they're no longer appropriate. Now, last Friday, at the UN General Assembly, IDLO and the UN jointly launched a program, an investment support program for LDCs, the least developed countries, to strengthen their capacity to negotiate contracts and settle disputes through arbitration. And I have rarely seen so much interest from all sides, everyone who was in the room, talking about how important it was to strengthen the legal capacity of these least developed countries to be able to negotiate properly complex contracts, investment contracts. And last week, we launched this program, and I hope that this program will be the basis of South-South cooperation, because this is exactly the kind of place where India, with its own experience of how it has dealt with investors, investment treaties, complex contracts, can share that experience with other countries. Now, international negotiations on climate change, as you know, India has advocated for equity and fairness, and arguing that there should be, yes, everyone has responsibilities, common responsibilities, but differentiated responsibility. And that as the global north has contributed more to global problems such as climate change, they should do more. And I was very pleased to hear Prime Minister Modi actually use the term climate justice in his statement at the Sustainable Development Summit in 2015, because this term, climate justice, was coined by the Mary Robinson Foundation for Climate Justice, on which I was a trustee until very recently, and stepped down because my term came to an end. And we devised that term because we wanted to show that justice has to be done in the context of sustainable development, where those who do the greatest damage should also pay more and should understand the unevenness of issues. And this is the real problem of sustainable development. Constantly you see people with less power and people or entities with more power. How do you balance the two? And this is where rule of law comes in, because a rule-based system can allow you to manage those diverse interests well. So to conclude, let me say, the rule of law helps to create the conditions for development by establishing the appropriate legal framework and the institutions. Secondly, it provides transparency and equity to the development process. It brings accountability and recourse mechanisms. And third,